Yeah.
I call the honourable member John Boscawen.
Thank you, Mr Speaker. I'm particularly proud to stand and take a call this afternoon on the Criminal Procedure Reform and Modernisation Bill on behalf of the ACT Party. And, Mr Speaker, the reason for that is that the bill that we're debating this afternoon is substantially and fundamentally different from the bill that was reported back from the Select Committee. And, sir, there is one party, more than any other party in this Parliament, that has contributed to that, Mr Speaker. That is the ACT Party, and I intend to explain to this House and to New Zealand why that is so this afternoon. Mr Speaker, there is much good about the procedures in this bill, the provisions in this bill. Without doubt, Mr Speaker, we acknowledge we need to deal with excessive delay, we need to deal with excessive cost, and we need to modernise the criminal justice system. So, Mr Speaker, there was much in this bill reported back to the House in July that all parties in the House agreed with. However, there were some fundamental disagreements, and those were ideally set out in the Labour Party report, the Labour Party minority report. And we've seen the Minister of Justice this afternoon identify the 6 major changes he intends to incorporate into the bill by way of SOP, Mr Speaker. And while I intend to deal with 3 of them in some depth, let me just summarise the 6 key issues that the Minister of Justice advised this House of earlier this afternoon. He said he intends to remove the issues in dispute provisions. He made a change to the jury trial threshold from 3 years down to 2. He changed the procedures that relate to trialling a defendant in absentia. Fourthly, he made changes to the cost order provisions. Fifthly, he changed the basis for a mistrial, a miscarriage of justice, from a substantial miscarriage of justice to a miscarriage of justice. And finally, Mr Speaker, he changed the threshold back from 12 months to 6 months in the case of minor offences. So he highlighted to the House, Mr Speaker, 6 of those major changes, or the 6 major changes. And what I want to say to the House this afternoon, in fact what I want to say to New Zealand this afternoon, this bill, as reported back to this House, all 640 pages, Mr Speaker, this was reported back to the House by the Justice and Electoral Committee with the recommendation it be adopted. And as the leader of the ACT Party, as the leader of the party with which the National Party has a confidence and supply agreement, I was asked by the Justice Minister, by Mr Power, in his office, to provide him the 5 votes to pass this bill. I was asked, on behalf of the ACT Party, for ACT Party support to pass this bill. And I have no doubt, Mr Speaker, had I given that support in August, this bill would have passed. It would already have passed through this House, but, Mr Speaker, it would have passed in a substantially different form. And, sir, while the SOP that makes those 6 major changes is but 4 or 5 pages long, the provisions contained in just these 4 or 5 pages substantially change, Mr Speaker, what's in the remaining the initial 640 pages. And I want to make it absolutely clear to New Zealand, Mr Speaker, that when I took this back to the ACT caucus, ACT's 5 MPs were absolutely united that they were not prepared to support this bill in the form that it was sent back to this House. Absolutely united. Now, Mr Speaker, I've identified the 6 major issues. I identified, Mr Speaker, the 6 major issues that the Justice Minister has already mentioned this afternoon that he has changed. And I want to focus on 3 of those. And the first one, Mr Speaker, is the requirement to identify issues in dispute. And to most New Zealanders, what does that mean? What does it mean to have to identify issues in dispute? And I would suggest to probably 99.9% of New Zealanders, it means very little. But, Mr. Speaker, it actually goes to the heart of our justice system. Most New Zealanders, Mr. Speaker, would know that when you are charged with a crime, a criminal offence, it is up to the state to prove the case beyond all reasonable doubt. Beyond all reasonable doubt. There is a massive mismatch, Mr. Speaker, between the resources of the state, the police, the investigating forces, the Crown Prosecutor's Office, Mr. Speaker, and our defendant. But it is up to the state, Mr. Speaker, to prove the case. The defendant, Mr. Speaker, under our constitutional democracy, is not required to do anything to assist. Under current conventions, the defendant is not required to assist in their prosecution. The defendant has the fundamental right to remain silent. It is up to the Crown, it is up to the police to prove the case, Mr. Speaker. And, sir, as this bill was reported back to the House in July, the National Party proposed to change that fundamental right. They proposed to take away one of our most fundamental rights and freedoms, Mr. Speaker, and to take away the right to remain silent, to take away the requirement for the state to prove beyond all reasonable doubt, Mr. Speaker, that the case had been found against the defendant. And when I listened to the comments of Simon Bridges this afternoon, and I'm very, very pleased that Carol Bowman picked up on this point, I almost got the impression, Mr. Speaker, that Simon Bridges didn't actually understand the bill. And if that's the case, Mr. Speaker, it's little wonder that the Justice and Electoral Select Committee came to the position that they came to in recommending this bill. Either that, Mr. Speaker, or Mr. Bridges is trying to seriously misrepresent the position as contained in this bill. Mr. Bridges said the arguments against this bill were reduced to a mantra. He argued that the right to remain silent, the requirement rather to identify issues in dispute wasn't actually under debate. Well, if he had listened to the speech of his own Justice Minister, Simon Power, he will have heard Mr. Power already raise the white flag. I surrender, I accept, I've made a mistake. And, Mr. Speaker, what this bill highlights, probably no more so than any other bill that has come to this Parliament in the last 3 years, is the fundamental importance of the ACT Party continuing in this Parliament and continuing to grow and to prosper, because it is the ACT Party, Mr. Speaker, who has upheld those constitutions. And you might say, well, what are the issues in dispute, Mr. Speaker? Well, what that required a defendant to do was to identify all of the areas that the defendant was going to challenge, to tell the prosecution in advance, this is what I'm going to rely on, this is my alibi, this is how I intend to defend the case against me. And that, sir, would have allowed the police to train witnesses, to help coach witnesses, help to present evidence in a particular way that would have made it much harder to bring that defence. And it fundamentally changed the balance, Mr. Speaker. Sir, another key issue is if you look at clause 376 in this bill, Mr. Speaker, and I'd like to read it verbatim. 376 is headed up proceedings not to be questioned for want of form. And briefly it says, currently, no charging document, conviction, sentence may be dismissed, set aside or held invalid unless the court is satisfied that there has been a substantial miscarriage of justice. Well, sir, right now the law provides that the test be a miscarriage of justice. And so most New Zealanders would think, sir, that if there had been a conviction or a sentence which represented a miscarriage of justice, they would have got off. They'd have been entitled to a retrial, Mr. Speaker. Well, that's not the case. That's not the case. The government intended to increase, sir, or to raise the bar. And finally, Mr Speaker, we've heard about jury trials. Well, sir, I campaigned against smacking offences. I campaigned against home invasion, Mr Speaker, and setting the jury trial limit to 2 years enables a person charged with those sorts of offences to be charged, Mr Speaker, and tried by a jury of their own peers. The ACT Party supports the bill, and we're very proud of the role, Mr Speaker, that we've played in having it in the form it is today. Thank you.
I call the honourable member Carmel